Okay, good afternoon everyone. Welcome to the first 3CL Travers Smith lunchtime seminar of the academic year. We don't usually start so late, but for a variety of reasons we've had to delay the start to our programme this year. But thank you for coming. And to compensate, we have a very high-profile speaker who I'm delighted to have with us. Actually, not who we get, Professor Kershaw on the programme, but not least he's on sabbatical this year, but I'm delighted to manage to pin him down and get him to Cambridge this afternoon. For those of you who don't know our speaker, Professor Kershaw is Professor of Law at the London School of Economics, and he is one of the most prolific corporate law academics that I know of anywhere, as well as his most recent book, which came out a couple of months ago, The Foundations of Anglo-American Corporate Fiduciary Law, which David will be talking about today, or at least talking about part of. He's also, in addition to that book, he's published Principles of Takeover Regulation, which is quite a beast of a book from a couple of years ago. And also, those of you who've studied UK company law may be familiar with Company Law in Context, his Cases and Materials book, with the second edition, I think, came out in 2012. Prior to his academic career, Professor Kershaw worked in the real world. He was a solicitor at Herbert in London, and also practised corporate law in the M&A group at Shearman and Sterling, both in New York and London. So as I said, Professor Kershaw will be speaking on his book today. I should add, by way of format, for those of you who are not familiar with our system, we have a 1 hour slot. Our speaker normally speaks for around 30 to 35 minutes, and then we have the remainder of the slot for questions. David has said he'd be willing to accept questions during his talk if anyone wishes to. There will be time after as well for that. So without further ado, I will hand over to David to speak on the foundations of Anglo-American corporate fiduciary law, connected assets, and the idea of property.
Thank you very much, Mark. It's really lovely to be here. So I'm going to try and speak for 30-35 minutes. I always go over, and we haven't really got any time to go over today, so I will do my very best to stick within that. So I'm going to talk about one part of my new book. I'm talking about the last part of my new book. I think Mark distributed a couple of chapters from that book. And the title of the part is referred to Connected Assets and the Idea of Property. Just briefly about the project, because I think it's quite a good idea to have a sense of where this project is coming from. Well, I think there are both primary drivers and secondary drivers of this book, of this project. The primary driver is a desire to excavate the source materials of UK and US corporate fiduciary law. Today, as many of you will be studying this year, if you've not done already, US and UK fiduciary law, corporate fiduciary law, is profoundly different. And yet, both UK and US fiduciary law started pretty much in the same place. They used the same source materials to generate what are today's corporate fiduciary standards, today's corporate directors' duties. And I'm interested in excavating those source materials, but also in the process of doing so, exploring how we have gone from there to here, how we've gone from a place where we were pretty much in the same place to a place where conceptually and substantively we are really at more or less opposite ends of the continuum. And as part of that exploration of why we've taken different directions, on the US side, what I'm particularly interested to show is that in the United States, where we end up, in part because of the interaction of an idea about America with these original English fiduciary law standards, to show that actually US corporate law does indeed embody, as Oliver Wendell Holmes once said, the story of a nation's development over the centuries. So those are the primary drivers. Secondary drivers, well, a couple of secondary drivers. The first secondary driver is to, through close doctrinal analysis, to challenge dominant ideas about why US corporate law looks like it looks today. In particular, to challenge the idea that, in large part, US and Delaware corporate law is the product of or reflects the imprint of US Corporate Legal Federalism, Charter Competition in the United States. And also what I wanted to do in this project is really to question Delaware. US and also non-US scholars a lot of the time talk about the sophistication of Delaware law. I have the view that it's not particularly sophisticated. Scholars often talk about the positive network externalities associated with Delaware law. This book shows, I think, that on the whole, Delaware generates negative network externalities. Okay, so let's move to the primary focus of today's talk. I'm interested today in exploring the relationship between the company and new opportunities that arise during the company's life. Opportunities arise, and the question is, and the question that corporate law has to grapple with, is in what circumstances can a director take that opportunity for herself, or in what circumstances can the company stop that director from exploiting and generating profits from that opportunity? Now, there are two core ideas, both in the United Kingdom and the United States, that underpin the law's exploration of when a director can take an opportunity. The first one asks the question, what duty does a fiduciary owe, a director owe, in relation to that new business opportunity? Does the fiduciary owe a positive, prescriptive duty to do something in relation to that opportunity, to get that opportunity for the company, or to tell the company about that opportunity? If there is a positive prescriptive duty, then taking the opportunity for herself would result in a breach of one of the fundamental fiduciary obligations. You cannot put yourself in a position in which your duty conflicts, in which your interest conflicts with the duty you owe to the company. Now, if duty is narrowly understood, though, that does a limited amount of work. If duty is understood narrowly, such as it is, or at least was, in a corporate context, duty is understood as a prescriptive obligation simply to, when you exercise power, to exercise that power in good faith in the interest of the company. If that is the extent of your duty, then unless the opportunity is formed in the process of exercising your duty, then that principle, that legal idea, will not be triggered, and the opportunity will be left for the director to take for herself, unless there is another legal idea that would involve limitations on the extent to which the director can take that opportunity. And there is a separate idea, this part of the book suggests, a separate idea about, in some circumstances, where there is a connection or a relationship, a close relationship or connection that feels like or looks like a property-like connection, between the opportunity and the fiduciary. In those circumstances, the fiduciary, the director, will be prevented from taking the opportunity. Now, there are 130 pages in this section. There are loads and loads of cases. You could literally spend the whole afternoon going through them all. So what I have to do here, in order to be able to tell you about the core ideas in this section, is to provide a flying trip through UK and US corporate fiduciary law as it applies to opportunities. So this is how I propose to try and do it. It is necessarily partial. So reflecting those two core ideas, let's start with the United Kingdom. The United Kingdom, there are two rules that apply to opportunities. The first one I call the first no profit rule, and the second one I call the second no profit rule. The first no profit rule is indeed that obligation that you cannot put yourself in a position in which your personal interest conflicts with the duty that you owe to the company. I call it for the first no profit rule because of from where it heralds. It heralds from late 17th century, late 18th century, early 19th century cases in which judges provided that it was not possible for a director to make advantage, to make a profit from the exercise of his duty. Now, in the English context, in the directorial context, courts provided that you could not put yourself in a position in which duty conflicted with interest, and provided for a very narrow prescriptive obligation. A narrow prescriptive obligation that required of directors only that when they exercise power, they do so to further the corporate interest. Not a positive, broad, prescriptive obligation in relation to an opportunity. The UK did not recognise a broad, positive obligation until the early 1970s. In the early 1970s, there is a transformation in the nature of this duty. A transformation driven by a very famous English case called Boardman and Phipps, and a transformation driven in Boardman and Phipps by one particular judge's judgment, Lord Upjohn. And Lord Upjohn moves us from a position of conflict of duty and interest to a conflict of interest. And from a conflict of interest, the law evolves towards a situation in which directors are thought to have, in some situations, prescriptive positive obligations vis-à-vis the opportunity. Now, but before the 1970s, the duty was narrow, prescriptive, which meant that in many instances, this obligation not to put your narrow prescriptive duty in conflict with your interest meant that many opportunities were simply untouched, effectively left to directors, unless there was another rule that caught those opportunities. That other rule is the rule that many of you, if you studied English company law, will know as the no-profit rule. And that rule, most of us English company law lawyers know it from Regal Hastings, is often said to be, you can't make a profit by reason of your position as a director. You can't make, a profit cannot be afforded to you as a result of your position as a director. Now, in fact, the book argues that was never the standard. The standard was never alone that a director could not make a profit simply by reason of his directorship. In fact, there was a separate component of that idea, a component that said there must be a connection between that asset, between that connected asset, that opportunity, and the company and the trust. Oops, I need to... and we can see that if we look closely at the cases that provided for this original no-profit rule. And I've not given you this to read because it's from the first part of the English section, but we need to look at this quickly to understand how this works. Mark, how am I doing for time?
You're fine.
10 minutes?
You get more than that.
No, have I been going for 10 minutes?
Oh, you've been going for 10 minutes. Yeah.
Okay. Yeah. If we look at these original cases where this no-profit rule comes from, they come from an idea in the late 18th century called an idea about what's called the right to renew. Several cases in which trustees held in trust a lease, and the trustee went away and acquired an extension to the lease for himself. And the question was, could that trustee acquire that lease extension? A classic case in this regard is a case called Keach and Stamford. And the court said, no, you can't take that lease for yourself. Okay, that lease is held in trust for the company. Why? When we reach Keach and Stamford, we draw the conclusion that the reason why they couldn't keep it for themselves was because they cannot make a profit by reason of their position. James and Dean, another example of that. If the representative, having become a tenant for life of that interest, has acquired a lease through the opportunity afforded to him during that short period, she would be a trustee. But if we look closely at those cases, we see that underlying that idea that you can't make a profit, you can't take the lease, is something more than simply that the profit was afforded to you by opportunity. It is not enough, said William Grant in Randall and Russell in 1814, to say that the tenant for life situation of tenant for life gave her the opportunity of making the purchase. They must go on to show what right or interest of theirs she acquired or defeated by making the purchase. In the present case, the plaintiff stood wholly unconnected with that asset. So there's an idea of connection, an idea that somehow there is an expectation for the beneficiaries that they will get that lease extension. There's no formal legal right that they will get it, but there's an expectation, a connection that feels like, although is never explained as, a property-like connection between the trust and the asset. I haven't got time to talk about this, that example. That was just an example of a 20th century case making the same points. Now, I need to move on quickly. So in the United States, we find a body of 19th century, early 20th century case law that tracks these two different ideas, but in very different ways. In the United Kingdom, this idea of connection never takes off. It's destroyed again by Lord Upjohn in Boardman and Phipps. Lord Upjohn in Boardman and Phipps says, information is not property. Knowledge is not property. It's open for all to see, and all those with eyes to see and with those ears to hear. Lord Upjohn in Boardman and Phipps takes away from English law this idea of connection. In the United States, what we see is the same two different ideas, but operating in a different way. In the no-conflict context, in the United States, they start with the duty and interest conflict, but move very quickly to a conflict of interest in the 19th century. So the standard in 19th century corporate case law is that you can't put yourself in a position in which your personal interest conflicts with the interest of the trust. At the same time, separate from this standard of no conflict of interest, in the United States, drawing on those same rights of renewal cases, Keach and Sanford, James and Dean, Randall and Russell, we see this idea developing. But in the United Kingdom, this idea of a property-like connection to the opportunity died, was never successful. In the United States, it works very effectively, in which the courts take that idea and say that the real question we're asking here is whether or not there is a property-like expectation vis-à-vis that opportunity. So I know I'm going quickly, but I need to get through. So in the United States, what we see, and what you've seen, if any of you look at the readings, is we end up with two separate legal ideas that operate distinctly and autonomously. The first one is that any duty that the director has, any positive duty the director has vis-à-vis that opportunity, is demarcated by a property-like expectancy. Okay, we got it out. And you only have a duty vis-à-vis that opportunity if you can demonstrate a property-like claim vis-à-vis that opportunity. Separately, distinctively, we have an idea of a duty of a conflict, not of duty and interest, but a conflict of interests. The first chapter that you've had to read traces those ideas into 4 New York cases in the 1880s. New York cases that draw very clearly on those UK cases, rights of renewal cases, and no conflicts cases. No time to talk about them all, but I'll talk very quickly about a couple. In Blake versus Buffalo Creek, the Blake versus Buffalo Creek Railway, the company had a railway line that ran over land owned by Buffalo City Council. They charged one of the directors to go away and get a lease over that land where they had laid their railway track. The director went away and took that lease for himself. He then sold that lease to a third party. The third party knocked on the company's door and said, "You have to pay us rent." The company refused to pay rent. When they refused, the third party went in, tore up the railway lines, and then sued the company for that rent. The company said, "No, we don't have to pay this rent because that property is held on trust for us." Why? Because the English rule is that you can't put yourself in a position in which there is a conflict of duty and interest. And here, the director had a duty to acquire that asset for us. And that asset was fundamental to the corporation. The court agreed, and therefore the director could not keep that asset. Robinson versus Jewett, here we see those original right of renewal cases flowing into US law, but in a different way. In Robinson versus Jewett, the company had a lease over property. The director took an extension of that lease for himself and sold it back to the company for a profit share. When the director sued the company for the profit share, the company said, "No, you hold that lease on trust for us." Why? Because of those English right of renewal cases. Those English right of renewal cases show that there is an expectancy in the lease expectation, and very importantly and distinctively in this context, the US court, the New York court, moves quickly to say, yes, between the director and the company, this extension is an expectancy which amounts to a property right. Something UK courts could never, until the 20th century, bring themselves to say. those cases flow into several key corporate cases, and probably the most important US corporate case is Lagarde versus Aniston, an Alabama case. We don't get many Alabama cases that are the leading cases in US corporate law. The Aniston Stone and Lime Company was a limestone quarry company, and here we have a limestone quarry, and the Aniston Company owned 1/3 of this quarry, and they wanted to acquire the other 2/3. They tried to buy this third, but they couldn't, but they took a lease in this third, and they had a contingent right to buy it. They negotiated for the final third for a while. Those negotiations weren't successful, and they eventually gave up. After they'd given up negotiating for that third parcel, 2 new directors were appointed. Those new directors came in, identified these assets, and went and bought both this one and this one for themselves. The Aniston Stone and Lime Company is outraged and brings an action claiming that those directors hold those assets in trust for them because they have breached their duties. It's a fabulous short case. The court starts with this broad loyalty obligation about conflict of duty and interest, but very quickly moves to narrowly define duty. Yes, you can't act in a way where your duty conflicts with interest, but what's your duty? Well, in this case, the court says there's 2 circumstances in which a director can have a positive duty vis-à-vis those opportunities. First, following Buffalo Creek, where that asset is essential to the creation and purpose of the company. Second, following Robertson and Jewett and the English right of renewal cases, where there is a property-like corporate expectancy in that opportunity. Now, the court concluded this asset was not essential for the company, so was there a corporate expectancy? In relation to the second parcel, where the company already had a lease, the court said yes, following those English right of renewal cases, following Robinson and Jewett, a lease extension is an expectancy, and therefore there is a property-like expectancy in the opportunity. You can't take that second parcel. What about the third parcel, where the company had been actively negotiating to buy that asset? Could the directors take that for themselves? The court said yes. Negotiation was not sufficient to create a property-like expectancy in the property. So what is then a sufficient to create a property-like expectancy? Is it possible that negotiating for the asset could do so? Well, in a subsequent case, in Reed de Bar-de-Leyden, by the same judge, Justice Sharp, same court, Supreme Court of Alabama, in this case, the court does hold that it's possible that active negotiation and expenditure to acquire an asset can create a property-like expectancy. Here, there was enough to create that property-like right. Now, that idea about when a corporation would have a claim on a corporate opportunity flows through then into the US Midwest and eventually then to the Eastern Seaboard, and we'll come back to Delaware in a minute, but we need to move on to the other lens. The separate lens that we find, distinctive, autonomous lens that we find in the United States, is the conflict lens. The conflict lens, which stems originally from this prohibition on the conflict of duty and interest, which becomes very quickly a broad prohibition on putting yourself in a position in which your personal interests conflict with those corporate interests. This is a seriously anti-director standard. Anything that the corporation is interested in can be caught by this duty. However, what the courts did in this context is they were very willing to practically limit the extent of the company's interest. So in Monroe versus Vanderbilt in 1963, Jasper versus Appalachian Gas, the company couldn't really afford the opportunity, therefore it wasn't interested, therefore there was no conflict. In Lancaster Loose Leaf, the opportunity, which was a tobacco buying and selling opportunity, didn't fit in the line of the company's business, which was a tobacco warehouse company. And therefore, as it was outside of its line of business, it wasn't part of the company's interests, and therefore there was no conflict. Now, in these cases, in contrast to the Lagarde line of cases, property is missing in action. And there's a good reason why property is missing in action. Property is missing in action because these two standards are substantively distinct. In nearly all of the property-based cases, the company had a general interest in the opportunity. The company could afford to take the opportunity. The opportunity was in the company's line of business, but yet the director could take that opportunity for herself because it's a completely different standard. These two standards are not congruent, and that's really important because what Delaware does, and what Delaware always does, is it combines and it harmonizes different approaches to a legal problem that you find in different US jurisdictions. Guth versus Loft is and remained the leading case on corporate opportunity in the United States, 1938 in the Chancery Court, 1939 in the Supreme Court. And this is a case, interestingly, dealing with a situation in which the president of the company bought shares in Pepsi-Cola company for himself. And the company, Loft, brought an action saying, no, those shares in the Pepsi-Cola company, they belong to us. And the framework that the courts adopts appears very clearly to be a property-based framework. They ask the question, to whom does this opportunity belong? And it's a complicated case, and we're just going to extract one particular idea, which is the most important idea from Guth. This is known as the Guth Rule, or the Rule of Corporate Opportunities, and these are the rules that Delaware provides to determine when a director can or cannot take an opportunity for herself. These are the rules that explicitly borrow from the range of cases we have very quickly referred to on the board. If there is presented to a corporate officer or director a business opportunity which the corporation is financially able to undertake, is from its nature in the line of the corporation's business and is a practical advantage to it, is one in which the corporation has an interest or reasonable expectancy, and by embracing the opportunity, the self-interest of the officer or director will be brought into conflict with that of his corporation, the law will not permit him to seize the opportunity for himself. Now, 10 minutes. Great, thank you, Mark. So what's interesting about this is, well, let's look. So first of all, financially able to undertake. Second of all, line of the corporation's business. Third of all, a broad no-conflict prohibition. These ideas are taken from the no-conflict line of cases that I've just referred to. Line of business, line to leave, financially able to undertake, Murray versus Vanderbilt. But look also, here we find in this same rule a separate standard, and is a practical advantage to it, is one in which the corporation has an interest or reasonable expectancy. So we have two different ideas that stem from English fiduciary law. But two different ideas developed in the US courts that are substantively distinct that Delaware combines in one standard. There is a deep indeterminacy in the Delaware rule because it borrows and it doesn't think hard about where it's borrowing from. Now, that structural indeterminacy has two consequences. The first one of which is that really most of this stuff is irrelevant. Because as we saw in Lagarde and Lagarde's progeny, in many of those cases, the opportunity was in the company's line of business, it could take the opportunity and there was a clear conflict of general interest, but the director was allowed to take the opportunity because there was no property right-like claim, even where the company was negotiating for the asset. So these factors are largely irrelevant. What really matters here is whether or not there is a reasonable expectancy. That's the core of this test. It is, at its heart, inevitably a property test because the property lens dominates. The second point to note, which the reading cover, I'm going to have to skip over this very quickly, is that this tension in the Delaware standard, this structural indeterminacy, plays out in future Delaware case law in really interesting ways. If we look at two of the main corporate opportunity cases in Delaware, what do we see? We find the Chancery Court and the Supreme Court disagree. Why do they disagree? Because the Chancery Court takes the no-conflict framework, and the Supreme Court comes along and says, no, you got that wrong. Why? Because we're going to take the property framework. So deep structural indeterminacy and uncertainty, driven by the fact that Delaware combines two substantively distinct standards. Now I've got about 5 minutes, right? 7. Okay, so I'm interested in this book in exploring shared heritage, but I'm also interested in exploring how we end up in such different places. Now, I went through the UK really, really quickly, but we're in completely opposite places today. Now, why then do we end up in opposite places, and why does the United States take the path that it takes? And the final chapter of the book explores three different ideas. Okay, I'll talk very briefly about two of them. First of all, charter competition, and secondly, the idea that I think is the dominant explanatory variable here, which is a different idea about the nature of property and the nature of property rights. First of all, charter competition. Now, those of you taking corporate law courses today will talk about this to death. One of the claims that has been made for a long period of time is that the nature of corporate legal federalism in the United States has an effect upon the nature of corporate law. And we've debated over many years the nature of those effects. One of those ideas, which I think is probably the most dominant of those ideas, is that in some areas of corporate law, we are likely to see very pro-managerial rules. This is Lucian Bebchuk's idea from about 25 years ago. And the reason is that in areas where activity is potentially significantly redistributed to directors, directors will be very keen to have rules that are pro-director, so that they can fill their own pockets as much as they possibly can. For Bebchuk, the key significantly distributed areas are self-dealing and corporate opportunities. Because here you can really, really fill your pockets. The United Kingdom is not subject to the pressures of regulatory or charter competition. The United States clearly is. What we see in the United States clearly are a set of very pro-managerial rules. Look at Lagarde. Look at Lagarde's progeny. Many situations in which English lawyers would say, of course, the director has to account for the company, but the director doesn't have to because there is no property-like expectancy. So there is a clear correlation between pro-managerial Delaware standards in this context and the idea and the theory of the effects of charter competition. But the book argues that there's a close attention to the historical record simply doesn't support this idea at all. The rules that we see have a long UK common law heritage, and they have a long company law heritage which predates any real possible existence of charter competition. Now, what I find really interesting here, and interesting in the different areas that the book covers, which again I haven't got time to talk about, maybe we can have the question, is that what's really interesting is that Delaware wins. Delaware gets more incorporations than anywhere else in the United States before it has any law at all. It doesn't have any opportunity law of its own until 1939 in Guth versus Loft. But that's interesting, but we need to move on. Now, 5 minutes. Okay, I can do this in 5 minutes. So, what then explains the different path taken in the United Kingdom and the United States, particularly in relation to this property idea? In the United Kingdom, we have in these very early cases an intuition that the reason why a director can't take an opportunity is because there is a connection between the trust or between the company and the opportunity, a property-like connection. But the courts never really struggle to explain it through the lens of property. We see a few cases that do, and then in Baldwin and Phipps, Upjohn slashes those cases down, and that idea completely fails. Whereas in the United States, that initial intuition that there is a property-like connection between the company or the trust and the asset is given lots of room to breathe and it flourishes really quickly. What explains that idea? Well, the claim that's made in the book is that the reason for that is very different conceptions of the role of property in creating property rights and the meaning of property when it comes to property rights. Most importantly in this context is in the United States a Lockean idea of the circumstances in which property can be created. So in the United States we have a theory of property that supports the initial intuition of those early UK cases. In the United Kingdom we don't have that theory of property, and this property idea dies. And its death results in a very different legal regime for regulating connected assets. Well, let's look briefly at those two different property ideas. So the first idea about property is that property, the label of property, does not ground the right. Okay? A right to an opportunity, or a right to a trademark, or a right to a trade secret is not grounded by the idea of property. Rather, in this first idea, property is simply a label for a bundle of exclusionary rights that are otherwise grounded. In the trademark context, we might use the property idea to refer to a trademark, but actually the reason why you get to keep that trademark and prevent other people from using it is because you have an exclusionary right based upon the fact that we can't allow other people to defraud the public. Or in the trade secrets context, the right, your exclusionary right, is based in English law on protecting a confidence that somebody has given to you. So in the UK, property is what Oliver Wendell Holmes referred to as a prophetic summary for other rights that are differently grounded. In the United States, although we see that first idea as well in the 19th century, what we also see in the 19th century is a Lockean idea of property. And here, property grounds the right. Property contains a substantive idea of why you have a right to an intangible, like an opportunity. This Lockean idea, interestingly, was formed to justify the taking of property in colonial America in the 17th century. And the idea is one that's very familiar to us. We have a right because of the fruits of our labor. We have a right to that opportunity because of the labor that we have invested. We reap what we sow. We have sown, and therefore we can reap that property. Here, property is a moral idea. It is prior to law. We put effort in, we put labor in, we generate that property belongs to us, and the law recognizes that effort. What Ayn Rand called in the mid-20th century, property by right. Now, what the book tries to do then is to show that in the 19th century and the early 20th century, in the United States, you had this idea of property was seen in many different legal areas, whereas it wasn't seen at all in the United Kingdom. And so the idea is then that this idea of property allows the intuition that we find in these early UK fiduciary cases, it allows them to flourish and to grow, whereas in the United Kingdom there is no fertilizer for that idea. A couple of examples from other legal contexts that the final chapter takes, and I need to stop talking. In the trademark context, Redaway versus Bannon, Lord Halesbury. The word property has sometimes been applied to the term trademark, he says, but I myself doubt whether it is accurate to speak of there being property in such a trademark, though no doubt some of the rights which are incident to property may attach to it. There are exclusionary rights that are otherwise justified, and because there are exclusionary rights, sometimes we use the term property in relation to that intangible, but property does no work. Whereas in the United States, one example from the New York Court of Appeals at the end of the 19th century, again in relation to the question of trademarks, Congress and Empire Spring, it's a big quote, it's worth reading. If, because I've almost finished, Mark, I promise you 2 minutes I'm done. If, as has been said, the origin of the right to a trademark is in the sentiment of natural equity, that within certain limits imposed by law for the benefit of society at large, everyone should enjoy an exclusive profit in the result of his powers of invention, ingenuity and skill. That sentiment is well invoked to protect everyone in the enjoyment and profitable use of the property in a peculiar natural product which he has acquired with the avails of his industry, sagacity and enterprise. It is a fraud to injure the owner who has and sells a specific article whose natural source is his alone. I could go on, but I need to save 30 seconds. Here we see a Lockean conception of how effort grounds the right. You can negotiate for an opportunity, but simply negotiating a little bit is not going to ground the right. In the Guide, it wasn't enough. In Read by Labour, the significant investment of effort, resources, and negotiation at the time was enough. And therefore, the company was allowed to reap what it had sown. Okay, and it's that idea of property that we see across multiple areas of intangibles in the 19th century that is the reason why those original fiduciary intuitions that we find in UK fiduciary law at the end of the 18th and beginning of the 19th century, it's why they grow into what is today the corporate opportunities doctrine in Delaware. In the United Kingdom, that idea was completely missing. So when judges started to say things like property information is not property, everyone said, well, of course it's not property. Property is simply a label for other for rights that are otherwise grounded. So if you haven't got a legal reason as to why that opportunity belongs to the company, then this idea cannot function at all. Now, the final point I need to make is that US law, Delaware law, ends up being very pro-managerial in this context. And the reason it ends up being pro-managerial is because of this conception of property. If your claim to a corporate opportunity is dependent upon you being able to establish a property-like right, a property-like expectancy, well, you're not going to get that easily, as we saw with the guard. You have to put a significant amount of effort into getting it. The reason then, I think, and the reason the book argues that Delaware law is very pro-managerial in this area through its property rights approach is because you have to work really hard to generate that opportunity. That's flying, isn't it? So,
I think you timed it nicely. Questions for, or observations for the